Streaming live on your mobile device with Radio Pup. This is WIBX First News with Keeler in the morning.
All right, in studio this morning is defense attorney Frank Policelli, and there are some people I want to get Pat has been waiting for a bit. I want to get him in with a question. Frank, of course, in response to yesterday's, were you surprised when they came back 2 hours later and all of a sudden, as you say, they had basically caved and come up with a guilty verdict? You had to be surprised.
No,
you were not
surprised.
Yeah, you're never surprised.
Never surprised what a jury's going to do.
Right.
I knew they wanted to get out of there, and I kind of figured that was going to happen.
Yeah. Somebody asked the question: why did you decide? Why was the decision made to not have Kaitlyn take the stand?
Okay. Any defense lawyer who tries cases knows the name of the game is burden of proof, presumption of innocence, reasonable doubt.
Yeah.
I don't have to prove anything, number one. Number two, she gave two interrogating statements where she said everything that she could possibly say. Okay.
Right.
What was there to gain by putting her on the stand to deny it again?
Right.
You know, you don't do that.
Yeah.
Any experienced, competent defense lawyer never puts their defendant on the stand unless it's a case that deals with specific intent or justification. Other than that, you don't do that, especially when you have so much doubt. First of all, it was an entirely circumstantial evidence case. If you put a defendant on the stand, you plug in the gaps that would otherwise be legally insufficient. So, no, you don't do that. You don't do that.
I know that I had heard through the grapevine that maybe my comments the other day weren't taken, the bull in the china closet describing you. To me, it was just it's strategy. But you referenced it when you did your closing argument. You said to the jury, you might not like me, or explain that. Your
well,
thoughts
you always
there.
do that.
Yeah.
Every competent defense lawyer explains to the jury that this is an adversarial system, and a lot of times there's going to be a lot of heated exchanges. Okay,
Yeah.
And I will say this: I do have the utmost respect for the prosecutors in this case. I think they're very competent, experienced lawyers. They were very professional in the way they acted towards me and the way they handled the case.
Yeah.
It's never personal. Okay.
Right.
But it's, I always analogize it to a sporting event in some degree, although it's certainly not a sporting event.
Right.
But, but it's adversarial.
Mm-hmm.
Okay. So you don't want to do anything that would offend anybody. And when you pick the jury, you let them know that.
Right.
Okay.
Right.
So they know what they're getting before the trial even starts. So, yeah, I say that in every closing argument, in every trial that I've had, and I've been doing this for over 40 years.
Pat is on the line right now in Whitesboro with a question for Frank Policelli. Pat, go ahead. What's your question?
Good morning, guys. My question basically is, could Frank actually directly answer the question that Jeff asked him, which he did not, which was the email account that was used to order the murder weapon? Could that have been tied to anyone other than Kaitlyn Conley? And when Jeff asked that, I didn't hear a yes or no answer.
Okay, well, let me be clear about it then, all right? Adam Yoder testified that he had physical possession of Katie's phone. There was also evidence in the case from David King that he had physical possession of her laptop. There was also evidence in the case that he built his own computer. He was a computer scientist. He had remote access. He constructed the Wi-Fi on the family residence.
Without a password, right? There was no
without
password.
a password.
Yeah.
So the answer to your question is he had complete access and control and could do everything he wanted with all the electronic devices.
So based on Sergeant or ex-Sergeant Martino's analysis, is it possible, based on that analysis, that anyone other than Kaitlyn Conley could have been the one operating that account to order the murder weapon? Yes or no?
Yes.
Who?
Well, you believe it would be Adam, right?
Of course.
Yeah.
Adam, yeah.
Does that answer? I truly think that's Frank has been clear on that.
Yeah.
You seem as if you disagree that with that theory, Pat.
Well, it's electronic analysis is much like a physical fingerprint, just in a digital way. and it tells a huge story. And I think the digital evidence in this case is probably a significant reason for the outcome of the trial.
Martino didn't disagree with that on cross-examination, what I just told you.
I believe he had admitted, yes, it's possible that somebody else could have been.
Yeah.
Now here, and Pat, I'm going to continue with this. Thank you, Pat and Whitesboro. Okay. In speaking with Kara Thomas from Spectrum News last hour, she brought up the fact that, and I'd be interested to know what you know about this. So to say that someone else had possession of the phone, access to the computer. But the prosecution came back and said, yes, but at the same time that she did A, B, and C, she was also texting her mother, which means talk to that.
Let me deal with that, all right? The evidence that they're talking about of the so-called research of these poisons, which was completely irrelevant to this case, okay, because you don't know if it was her doing the research, why she was doing it, because you don't know when it was done. All you have are screenshots. You can't tell from a screenshot when the original research on that phone was done, okay?
Okay.
So it's meaningless.
Got it. So there's no way to tie it. So so they were not able to. So they really couldn't.
And Martino testified to that.
Yeah, they did not. They were not able to prove you absolutely wrong when you said it could have been somebody else.
Correct.
They couldn't prove that.
That's right.
What was it like yesterday? I mean, you've done this a long time. The rest of us, we've watched. It had to be tough.
Yeah. Oh yeah, it always is.
Yeah.
It always is. You know, it's the, it was.
She seemed strong in the courtroom. Did she break down at some point?
Never.
Did not.
Nope.
She's tough. You believe she's tough?
Yeah. I mean, she believed in the system. She believed in her innocence. And let's not forget, what I could not get into evidence before I took this case. Well, when I took this case, I says, listen, before I take this case, I want you to take a polygraph exam for me, so I'll know in my own mind that you're innocent.
Yeah.
She took a polygraph exam in June and passed it with flying colors, okay? On the question, did you cause Mary Yoder to ingest the toxin colchicine on July 20th? No. No deception indicated at all, okay? Now, I couldn't get that into evidence because you can't get polygraph evidence in court in New York, okay? But I knew in my mind that she was innocent, okay?
Was there a point, did you ask the question, did you inadvertently cause the death of Mary Yoder? I mean, is it possible, and I brought up a crazy theory that I was hearing tossed around yesterday, if this was a theory, why didn't the prosecution go with this, that her intent was actually to kill Adam Yoder? No. I'm just asking you, and you're laughing, and
she never had any guilty knowledge of anything. She was used, okay? She was a patsy,
I also found it interesting that if she was so good at putting all of this together, how did she leave such a trail?
How could she be so stupid?
How could she be so stupid?
How could she be so diabolical in one way and then so stupid in the other way? Exactly. You know?
All right.
It makes no sense.
John is in Cassville. We're talking with our interview this morning with Frank Policelli. John, you're on with Frank, and go ahead with your question.
Hi, gentlemen. How are you doing this morning?
Good.
Just had a quick question. With the jury coming back so quickly with an indecision or not able to make a decision, and then the judge directing them back to chambers or back to the jury room to make a decision, and they come back all agreeable within a short amount of time. To me, that seems wrong. Is that an option for an appeal for you going forward? Just curious.
Yeah, let's get into the good question. Let's get into that appeal.
It certainly is an issue. I don't know if it's the strongest point on an appeal, but it certainly is on the record for appellate review.
Do you feel that the judge, and you said you respected everybody involved, from the judge to the attorneys, everybody. Do you feel, and I was only able to read what the judge said, and I almost felt that it was a bit harsh. Do you feel that way, Judge Dwyer? And when he sent them back saying, don't let some preconceived thought, your pride, don't let your pride get in the way.
Well, he read what we call the Allen charge, okay?
And does that specifically say don't get your
he read it word for word.
Okay, all right.
The criticism in the legal journals are about whether you ever give an Allen charge at all and when do you give it. Okay, but Allen charges are permissible under the law, and in all fairness to the judge, when the jury comes back and says we're hung 10-2 on manslaughter, what do you tell them?
Right.
Okay,
Go back and
you got to give them that Allen charge.
Yeah.
I don't know. Well, my suggestion was to just go back and tell them to continue deliberating without the Allen charge,
right?
Because the Allen charge is so demanding. Now, I've had cases where I've had 6 hung juries in my career. Okay, and usually they go for days. I'll never forget 20 years ago on a night of research service, the jury was out 15 days.
Yeah.
And the judge gave them 2 Allen charges, and they still ended up hung. So it's usually a longer period of time. But when they say we're hung, in a way, the judge is put in a situation where he's got to tell them something.
Yeah. And you said that she was strong yesterday. Did you talk about the appeal with Kaitlyn? I realize you're going there today, and
I'm a worst case scenario guy. I've been in this business a long time.
Yeah.
Okay, so I always prepare clients for the worst case scenario.
She did seem prepared. I mean, it looked like she mouthed back to her family, "I'm okay."
Yeah.
That's pretty strong.
Yeah.
So that's something you guys have discussed, then.
Well, I discuss that from day one when I'm talking to a client. No matter how confident I am and how well I try a case, the hardest thing for a criminal defense lawyer to do is to second guess himself and say, well, what could I have done? What should I have done differently? And when you come back and say nothing, then, what do you do,
Jeff?
Can I ask, you mentioned the polygraph earlier. Do you typically do that for clients?
I've done it. I wouldn't say typically, but I have done it on many cases.
Okay. And they're going to say, obviously, they're going to say that's not admissible in court. It's not.
I just thought it was
recognized as scientifically accurate.
Although it's becoming, because of the technology is becoming increasingly more scientifically reliable. It is being accepted in more and more jurisdictions. So you still try to get it.
If she failed the test, would you not have taken the case?
No, I would have probably still taken the case. I probably would have taken a different approach, though.
Yeah. I thought that was interesting.
Yeah.
That you want to know whether your client is innocent or guilty.
Some cases. I mean, as a practical matter, does it matter when you defend a case? Absolutely not. In some cases, you do want to know. In this particular case, I wanted to know.
You seemed in this case to not go point the finger at the father.
Right.
And I do have to say, just from the outside looking in, the most obvious, the only motive that existed would have been the husband. And the classic, the husband finds someone else and is looking to move on and
but that doesn't fit the evidence in this
You don't
case.
believe that fits?
No, I mean, if you look at all the evidence from the beginning, when she goes to the police, when she writes the letter, when she's interrogated, it's all about Adam.
Right.
And it's possible. But here's the thing with that, with the husband. Okay, when they asked if anybody paid any attention to my cross-examination, which they had read back of the husband. He testified that when Mary came home, she said that she started feeling the symptoms at 1:30 in the afternoon. Okay, the toxicologist, Marafa, the poison expert, says there's no way you would be getting symptomatic at 1:30 in the afternoon, no matter how much colchicine you ingested,
right,
if you ingested it between 1 and 1:30. It would take at least 2 to 6 hours to be symptomatic. So he testifies in the grand jury, 1:30 in the afternoon is when she said she became symptomatic. The district attorney asks him in the grand jury, "You sure it wasn't 4:30?" "No, it was 1:30." Okay. Now he comes to court. In this case, he says, "I was mistaken. It wasn't that." Because he wants to tailor his testimony to fit the prosecution's theory and be a biased witness. He also didn't know if she had breakfast that morning. So if she did have breakfast, and if she took her supplements at breakfast, and her pill organizer, which was never produced, and the colchicine was in one of those pills, then it's quite possible she would have been symptomatic at 1:30 in the afternoon. Another reasonable doubt, okay?
If she thought that Adam had committed this crime, why didn't she just go to the police?
She did.
She did.
She sent the letter.
The letter. But why not just go to the police?
Because she was scared of Adam.
Okay.
And she says that.
Yeah. And was there was testimony about we'll call it domestic violence, but others had said, well, it didn't fit. The days didn't fit. I mean, was the domestic violence admitted to? The rape, was that admitted to?
Adam testified he was so drunk he didn't remember.
Okay.
But then you have text messages to prove it. So they come back and say, well, you're probably lying about that because you went and you went out on his birthday and you were celebrating with him and you were with him after that. Now, anybody that knows anything about domestic violence and how people are abused knows have you ever heard of the Stockholm syndrome? Where
right.
You forgive your captor. Okay, so that certainly the reason that's important is to show what kind of a person Adam was.
Right. The DA, we're going to speak with Scott McNamara in a few minutes here after 8 o'clock, and he's probably going to tell us the evidence is there. Frank says the evidence is not there. Everything points to Kaitlyn Conley. How do you how do you respond to that?
I don't know
what
the
phone,
is.
all the
points to what?
Circumstantial evidence.
Did she put poison somehow? Did she poison her between 1:15 and 1:30 on July 20th? Where's that evidence?
Can I ask you this? Just one note on Adam Yoder. He was never charged. I don't know if it was investigated, but that was part of what your client had alleged, that he had been abusive. Correct? I mean, there was never.
She did go to the police. She did file an affidavit. She did make a controlled phone call, but she didn't pursue it.
Okay, I just want to be clear.
Common among women who have been.
I think that is
anybody listening. It wasn't like he was charged, investigated. Right. This is a claim that and I'm not.
He was investigated because they had a controlled phone call.
Okay.
But on the controlled phone call, he said, "I was so drunk I don't remember. And by the way, I think you cheated on me." So he changed the subject.
Okay. One quick question on whether or not there was any evidence, and you believe it was Adam, and that he had access. Is that correct? That's what you seem to be alleging.
Did access? What do you mean?
I'm
access
sorry, to the email.
phone, to the email,
access to the phone,
to the
computer,
email,
etc.
He admitted that.
Yep.
Why wouldn't he point the finger at someone else? It doesn't seem like I had heard originally that maybe she was being framed, but it doesn't seem like anybody. If someone else was responsible, it doesn't seem like somebody was making an effort to point the finger at her. Do you follow what I'm saying?
No.
I'm sorry, that wasn't a great question.
Well, it seems. I mean, if the theory is that the pointing to her was the fact that there was the email, there was the internet, the screenshots, all of these things.
Well, the things that pointed to her was the fact that the office computer was used, and she was one of the persons who used the office
the thought
computer.
that they'd be able to find this in backup would, I mean, that would be a pretty big leap for Adam.
Her phone.
Okay. He did the backup
on his computer.
But what I'm saying is,
that's typical of a jealous. That's typical.
Oh God, he did it twice.
Yeah. Okay.
He had access. You're saying he had access to her phone, her laptop. There was this email account,
the office computer.
The office computer. He could have accessed all these things. I'm just saying, if he was responsible, he didn't make any effort to point the finger toward her. Do you understand what I'm saying?
Okay.
So the idea originally was that maybe
I wonder if I can just take this. I wonder if the theory that you have is that he really didn't frame her. It wasn't about framing her because he never intended to have her die in the first place.
Exactly. Yes.
I understand. Okay.
Yes.
That kind of clears that up.
Yes.
All right. We're talking to Frank Policelli. I appreciate your time this morning.
Okay.
It's almost like you're on the stand this morning.
Fine with me.
But you're handling it quite well. I do want to ask you. What are you going to say to her? You're going to first of all, what's her life going to be like now? On appeal, it's no longer house arrest. And what are you going to say to her today?
Well, the first thing I'm going to try to do is see if we could get her bail pending appeal. That's a very rare thing that happens. And the only way you could get an appellate judge to grant bail pending appeal is if you could show there's a substantial likelihood of success. So we've got to put together our legal arguments.
And will they expedite that? The appellate can be pretty long.
We can't. Well, here's the thing.
She's spending time in jail.
I've done this before. Here's the way it works. After she gets sentenced on January the 11th, we file a notice of appeal, and at the same time, we make a motion to the appellate division for a stay pending appeal and get bail pending appeal. Now, under the statute, if they grant you bail pending appeal, you have to show that there's a substantial likelihood of success, that you have a legal issue that you're probably going to win on.
Got it.
And then you got to get it done within 6 months.
So this moves quickly. This would move quickly.
It can move quickly. Yeah. Okay.
And your success rate on using this?
I can't remember all the times I've done it. I've done.
But you've seen
about
them.
100 appeals.
You've seen them allow the defendant to.
I've seen it happen, but it's very rare that it happens.
Okay,
it's very rare.
So chances are that they deny that. How long will she spend time in jail before you get your appeal?
I do appeals faster than probably anybody.
All right.
I do a lot of appeals, okay? And in my experience, as soon as we get the transcripts of the trial, that's going to be a delay, but the stenographers are pretty good around here about getting you the transcripts. Then so you get your record, you get your transcripts, you get your legal briefs and paperwork that's on the court below. You make what's called an appendix. You get your record on appeal, you write your brief, and you file it. As soon as I get that transcript, I could have this appeal filed within 6 months.
All right.
And then by the time it gets heard by the appellate division and you get a decision, it's probably a year.
Okay. Frank Policelli, I appreciate the time this morning.
Well, you're welcome.
And we wish you the best on this. Good luck today. It's going to be a tough morning you're gonna have, I would assume.
Well, she's not the only person I got to see on the jail that's been charged with murder either. So.
All right. So you're going to have a busy morning, then.
I have a busy morning.
Right. We appreciate the time. Next up,
thank you.
Scott McNamara, the DA's office on WIBX.